This employment law video is on harassment outside work. An employer may be responsible for the discriminatory acts of its employees where the wrongdoing is carried out in the course of employment, unless the employer can show that it took all reasonable steps to prevent the employee from doing that act. Harassment. Our equality legislation prohibits harassment related to a protected characteristic, such as age, race, sex, disability, or sexual orientation. This happens where a person engages in unwanted conduct related to the protected characteristic, which has the purpose or effect of violating someone's dignity, or creates a hostile, humiliating, degrading, or offensive environment for them. Sexual harassment is also prohibited where the conduct is of a sexual nature. Vicarious liability. An employer is vicariously liable, meaning responsible, for discriminatory acts of employees where there is a sufficiently close connection between the wrongdoing and the employment, i.e. it can be regarded as in the course of employment. The equality legislation widens the definition of employment for the purposes of discrimination, and an employer is liable for any acts of its agent, such as solicitors or accountants. Acts outside work could be considered in the course of employment. For example, sexual harassment carried out at a work social function, even outside work, is likely to be sufficiently connected with the employment. Did the employer take reasonable steps to prevent the harassment? The employer has a defence to a discrimination claim if it can show that it took reasonable steps to prevent the discriminatory act from occurring. This is a high hurdle to get over, and it would be necessary to analyse what steps would have been reasonable to take. Some steps that might be relevant could be regularly communicating an equal opportunities policy, providing equal opportunities training, dealing with complaints, and taking extra measures if the employer has a suspicion or concern about a particular employee. Third-party harassment. Previously, employees could bring claims against their employer for third-party harassment, where the harassment occurred on at least 2 occasions and the employer was aware of it but failed to take reasonable steps to prevent it from happening. This provision in the equality legislation, however, was repealed in 2013. Depending on the circumstances of the harassment, whether carried out by an employee or a third party, there may well be other action to consider, and you should always take legal advice at the earliest opportunity. That's my video on harassment outside work. The usual caveat is that this video is for guidance only and should not be relied upon for specific advice. For more information on harassment, time limits and claims, do visit my website. And if you're interested in receiving notifications on other employment law videos, do subscribe to my channel.